I don't want to interrupt the conversations. Actually, I do want to interrupt the conversations because they're great lunch that we'll have scheduled today. I'm delighted to be able to introduce to you Professor Larry Sager. Before I turn to that, this is our last of the talks in the Osgoode Colloquium on Law, Religion, and Social Thought for the year, not the last in the series. But that being the case, I wanted to just right at the outset extend thanks to a couple of people. First, Jody Ann Rowe Butler, who just stepped out, who's integral to getting really any of the events around the school up and running. And secondly, to James Chang, who's done the artwork for the posters and for the PowerPoints all throughout, both this year and last, and I'm grateful to him. Both of them set the stage for wonderful speakers like Larry Sager, who I'm just delighted to have at the school today. He's the Alice Jane Drysdale Sheffield Regents Chair at the School of Law at the University of Texas at Austin, and he is really one of the most creative, provocative U.S. constitutional theorists who has really shown an abiding sensitivity to the varieties of ways in which we can imagine and live constitutional lives together. Larry is a disruptive person. He was disruptive of mostly, though not exclusively, complacencies in the way we imagine our constitutional lives. And he is rightly celebrated for a volume that many of you will be familiar with called Justice in Plainclothes, which pushes us to think about the ways in which we can imagine constitutional life that isn't focused merely on one or two interpreters of the Constitution. And his most sustained engagement with issues of the constitutional protection of religion, a book that he co-authored with Chris Eisgruber called Religious Freedom and the Constitution, challenged, disrupted conventions on how, and very interestingly, whether religion should be given constitutional regard at all. I had the great pleasure and fortune of meeting Larry Sager about 10 years ago, and then intermittently ever since, and it's a particular pleasure to bring him to Osgoode and to have him at the colloquium. So please join me in welcoming Larry Sager.
Thank you.
His brother right under the foot.
Thank you all. I want to begin by thanking Ben, not least for that handsome introduction, and one that actually has at least enough truth in it that I can recognize myself in it, so thank you. I also want to thank Ben for inviting me here today and for maintaining a professional friendship that it turns out goes back not just to a conference at Canberra, which is what I recalled most proximately, but also to a graduate seminar at Yale that I attended and Ben was at. So Ben, thank you very much. And thanks to all of you for coming today. What I want to talk about today sort of has two halves. Ultimately, what I want to talk about is a project that Chris Eisgruber, in this area, my colleague and co-author for many, many years now, on religious liberty, but it's a project which grows out of our sustained work together and which represents, in some sense, a kind of a sharp turn in that work. I'm not going to say to the left or to the right because I don't want to give that turn a political valence, but so to sort of indicate not just the nature of our current project, but also the sharp turn-ishness of it all, I want to spend a little time talking about Chris's and my basic understanding of religious liberty, which was at the time in some ways and still is controversial, and which fits in this uneasy tension with what we're doing now. But that's part of the point. So I'll spend about half my time talking about the past and half of my time talking in a certain way about the present or future of our work. Chris's and my basic commitments until recently have been to try to understand religious liberty within the context of the American constitutional tradition. And our project began in certain ways with a kind of negativity. And the negativity centered on the way religious freedom was thought about in the American constitutional tradition often, which grasped this metaphor of a wall of separation between church and state. And the wall of separation metaphor had a kind of peculiar conceptual life of its own. And most particularly, it underwrote the idea that money was never supposed to pass over that wall from the state treasury to religious organizations. And it also went so far as to suggest that the regulatory authority of the state shouldn't pass over that wall to religiously motivated persons, except in rather dire circumstances. When the state's concerns grew to a very high threshold, sometimes described by the compelling state interest test, then and only then could the state regulate religiously motivated conduct. We thought this metaphor and this approach was implausible, disconnected with the way the world really was, and morally unattractive to the degree that it had traction on American law. Churches and religiously motivated people are woven into our lives. They use public services, they spend money on politics, religiously motivated people affect the welfare of others and draw benefits from being citizens in a democratic state. And for a variety of grounds, we found this notion unattractive. Not least, by the way, its implications for unequal treatment. Under this separation of church and state, it was always important to decide what was truly religious and what was not religious, and either special benefits or special detriments attached to the label of religion, so that religiously motivated people had get-out-of-jail-free cards against many public regulations. And religious organizations were starved of public money. So religions suffered in special ways, religions benefited in special ways, and the very inequality of all that struck us as morally indefensible on equality grounds, and indeed sometimes produced genuinely paradoxical cases, which kind of lent to the notion that this was an incoherent approach. So some of you may be familiar with the St. Bartholomew's controversy in New York, where a religious church wanted to build an enormous skyscraper behind itself and was blocked by landmark preservation laws. And one group argued quite plausibly that they were entitled to this under the notion that they were entitled to be free of regulation, except when dire public interests were at stake. And the landmark preservation in the city of New York didn't seem to rise to that threshold. Other people said, you can't send money to religious groups. That's a truism of religious liberty in the United States. And when you give a group a special exemption that has staggering financial benefits, you're violating the rules. So the two implausible threads of religious liberty driven by separation collide in the St. Bartholomew's case. In any event, Chris and I took a step back from all this and still take a step. We're still committed to all this. And our view is, first of all, the reason that religion enjoys special stature in American constitutional life is not that religion is privileged, it is that it needs to be protected. And it's not religion, it is the whole area of religiousness and non-religiousness. Our notion is that for a variety, and this won't be surprising, but we can talk about it, for a variety of cultural and substantive reasons, religion, non-religion, religious belief, anti-religious belief, religious behavior is the site of a great deal of discrimination in modern states. History underwrites that, and other circumstances underwrite that. It's actually fading, I think, in its rich potential for discrimination, and that's an interesting fact in the matter. And our thought is that religious liberty in the United States is all about equality, not about treating religion specially, but protecting religious and anti-religious and minority religious belief and secular belief when compared, protecting it from discrimination. For us, religious liberty is about equality, period. And we had this famous fictive example, although it was based on an actual Richmond, Virginia case, of two women who lived across the street from each other in a suburban community, both of whom were deeply moved to have soup kitchens to feed the poor. And we imagine one is exquisitely religious. They're both called Mrs. Campbell, by the way. We couldn't resist the Mrs. Campbell soup stuff, I'm sorry. So one Mrs. Campbell says, I'm deeply driven by religion. Indeed, my God spoke to me and said, go forth and serve soup to the poor, that they should not be hungry. And the other woman says, I don't even want to talk to you about my religious belief. It's irrelevant. I'm doing all this because I care deeply about human suffering and about starving children and their parents. And I won't even submit myself to the claim that this is religious or driven by religion. I do this for humanitarian grounds. And our claim was that any discrimination between those two people, whichever way it ran, was on the fault line of the discriminatory potential for religion in America and violated a powerful equality principle. Now, underwriting all this in our mind was the idea of equal membership. And the basal moral norm of equal membership goes something like this. A state must accord equal status or stature to all persons within its jurisdiction, without regard to their race, their ethnicity, religion, or other fundamental aspects of their identity. So equal membership, we believe, is the moral foundation of religious liberty, at least in the United States. In application to a pluralist democracy like the United States, equal membership ends up in our hands in a pretty ruthless set of demands for equal treatment. And those ruthless demands on our account for the most attractive features of religious liberty in the United States. And I'll just sum them up quickly. I'm going to have to tell my laptop not to constantly keep changing its mind about where it is. Okay. I'll name 3 consequences of applying equal membership in the United States constitutional tradition as we interpret it. The first involves accommodations or exemptions from general laws. And the basic notion is that the constitutional dimension of accommodation is entirely equality driven. If the state decides to provide powerful secular concerns or majority religious concerns, special exemptions from otherwise general propositions, then it has to give those exemptions out fairly. Has to give them to minority religious beliefs. If they're given to religious groups, it has to give them to non-religious groups. If it's given to non-religious groups and religions are excluded, that too is wrong. Exemptions have to be distributed fairly across this venue of religious belief and commitment. And on our view, that accounts for virtually all the attractive aspects of religious accommodation in the American tradition, and actually provides for a relatively robust set of accommodations, which I'm glad to talk about, but if I get started, I won't get to Israel. Secondly, we think the school prayer cases, the public monument cases, all the symbolic so-called Establishment Clause cases in the United States tradition, we're not very given to thinking that establishment and free exercise come from a different value set. We think there ought to be a coherent moral norm, and we think it lies in equal membership. We think all of that trigger-happy stuff in the American constitutional tradition, which we endorse, and then some, grows out of the problem of public meaning, where the public meaning of prayer, monuments, rituals, and public statements is denigrative of some persons because of the spiritual foundations of their commitments, then that violates equal membership. So we think this is all about the public meaning of public displays, prayers, and so forth, and intimately connected with the nature of religion, so that it's just fine. We had to search a long way, by the way, to find the name for a fictive community that didn't exist in the United States, and I don't think we ever quite found it. But we ended up saying Finesville, because if there is a Finesville in the United States, it's really obscure. So if Finesville has a sign over its portal which reads, Finesville, a nuclear-free community, the way a lot of communities in Europe and possibly in Canada identify themselves, that takes a position about a provocative political and social issue, but we don't think it raises constitutional problems. But if it says Finesville, a Catholic community, or Finesville, a Christian community, then it commits a deep constitutional wrong because it is denigrative of, its public meaning is rather self-evident, and it's denigrative of other places. I say that against interest because when we get to Israel, we will be running into ourselves. And finally, we think that programs that involve public funding of what ultimately may be religious enterprises, 12-step programs, schools under school vouchers, other ways in which public dollars reach religions, potentially in the United States. We think that that is not barred strictly by the Establishment Clause, as earlier Supreme Court cases said. We think, however, such public funding that touches religion has to be under strict concerns of fairness. It has to be equitably distributed, and this will come back affirmatively when we talk about Israel. It's crucial that that the service involved have a robust secular alternative. So if 12-step programs are going to be religious, there have to be substantial secular 12-step programs, and that's really a condition of equity and equitable access. So in some ways, the three most prominent features of religious liberty in the United States, accommodation, public displays, et cetera, prayer and all of that, and public funding of religious enterprises, we think that is all governed and explicable by equality norms and based on, in a sense, a peculiarly sensitive, robust, and particularized equality principle, a special equal protection principle, if you want to think about it that way. Historically, of course, the protection of religion in the First Amendment came before there was an equal protection clause. So it's a little less implausible as just a linguistic or structural matter. Okay. Now, that's basically all I want to say about our view about religious liberty in the United States, except to state what may be obvious. And that is, this is all based on what we could call a justice-seeking view of American constitutional interpretation. It is, if you will, a highly moralized account of American constitutional law. We think it accounts for the most attractive and durable features of constitutional law, and that it has that obligation of accounting for what is there. But it is a highly normative or moralized account of constitutional liberty. That's important to mention at that point because it was always our view that what we were saying might be an impressive account, we believe the best account of American constitutional law, but it was always our ambition to lay down principles of justice which were portable to other national environments. And that's where the new phase of our project comes in. And that's where a certain problem arises, which is the kind of ruthless equality that exists in American constitutional law of religion, and which we underwrite emphatically in our discussion of it, doesn't get satisfied hardly anywhere in the world. You know, and if you have a view of political justice, which only one nation in the world satisfies, and more embarrassingly still, it's your nation, that's uncomfortable. So we have been provoking ourselves or pushing ourselves to raise our gaze to the world stage and to ask about whether some forms of apparent partiality, which seem to manifest themselves almost everywhere, are consistent with equal membership. And this is quite important because to us, equal membership is an unwavering demand of political justice. So it's quite critical to ask the question whether and when some forms of partiality are consistent with equal membership. And I must say we have grasped the nettle in our first foray out because we are asking about an Israel in thinking about this question. This is the first time ever in public I've used the expression "an Israel," which seems odd, but there's a reason. I'm saying "an Israel" because I want to stress Israel is for us a kind of thought experiment. And we are asking about whether Israel could satisfy the demands of equal membership. We're not asking whether it does. We're not, in effect, giving it a report card. But we are starting with an important feature of Israel, which makes this a very challenging first look at this question of partiality and equality, and that is with the founding documents of the Israeli state. The founding documents of the Israeli state embrace two prominent commitments among 3 or 4 altogether. One commitment is to be a Jewish state. And the second commitment, and I'm going to quote, is that Israel, quotes, will ensure complete equality of social and political rights to all its inhabitants, irrespective of religion, race, or sex. It will guarantee freedom of religion, conscience, language, education, and culture. Now note, complete equality of social and political rights, taken half seriously, is a robust commitment. It's a much more prominent commitment, for example, than the Equal Protection Clause of the 14th Amendment to the American Constitution. So our question in the work that we are now doing, which is where I will now veer, and how far am I, about 20 minutes in or a little more? Am I doing okay? Good. Because I want to devote that. Could Israel do those two things? Could it be a Jewish state? And could it respect, if you will, equal membership? And our conclusion is a cautious one, but it is yes, but that it would take a lot of hard work. And I want to stress that we're not giving Israel a report card. And if we did, it probably would not be a cause for celebration. I'm happy to talk about that. But most importantly, it is the, if you will, conceptual experiment or thought. Could Israel satisfy these two commitments? And in effect, what would it have to do? Now, our analysis of Israel that reaches this cautious affirmative action travels through the idea of a homeland. And what we mean by a homeland is a place of secure refuge, which includes the comforts of recognition. And the comforts of recognition mean a place where people's values, commitments, and traditions are familiar and shared by many other people. So a homeland is a place of secure refuge which extends the comforts of recognition, a place where values, commitments, and traditions are familiar and shared by many. Not necessarily, by the way, a majority, but by many. And we conclude that a homeland state, even a homeland state that is defined ethnically and in part even religiously, can satisfy the requirements of equal membership, provided that 3 conditions are satisfied. And I was going to take them up and amplify them, but maybe I'll just name them and then go back over them, because they involve a conversation in each case. One condition is the homeland must be established, or at least fully justifiable, on the basis of justice regarding purposes. So the homeland has to be done in the name of, plausibly and attractively, in the name of justice. We can talk about what we mean by that and why it figures. Secondly, the comforts of recognition offered by a homeland have to be closely tailored, if you will, have to be ungenerous to the idea of a homeland. And we police that by a sort of specific requirement of carefully tailored, namely, wherever the comforts of recognition give rise to institutions, arrangements, or prerogatives which can be distributed widely throughout the culture to non-homeland peoples as well, they must be. And I'll immediately give content to that. That's easy to describe, especially in terms of Israel's absolutely screwy marriage laws, which I'll come back to in a moment. And thirdly, and perhaps most importantly, there is a requirement that we name solicitous inclusion. And what we mean by that is a homeland state is so precariously poised with regard to equal membership and the non-homeland minority that a homeland state has to bend over backwards in making material and symbolic efforts to maintain the values of equal membership. And I'll give some concrete instances. And that bending over backwards we describe as solicitous inclusion. Okay, so let's just march through those. It's not hard to explain how it could be that creating a Jewish state in Israel was, in an important sense, not trying to defend its overall justness now against all historical circumstances, but that it could be understood to be driven by justice regarding purposes is very easy. It was creating a secure home for people who had no home and whose homelessness had resulted in a vivid human catastrophe. Equally important is to observe, and this will become very important in conversation here or elsewhere, we do not think a justice regarding reason could be offered for converting the United States into a Christian homeland, for example. You don't just get to say we're now going to be a homeland for the Jews or the Catholics, or there has to be a justice behind that. We'll come back to that and why that might be. We don't think, by the way, that homeland status may be the only source of partiality, and we don't think that justice may be the only legitimate purpose for underwriting some forms of partiality. But we actually think that in the United States, a pluralist democracy, there are no such purposes underwriting partiality. And that's partly what produces the sharp demands, the ruthless demands for equal treatment. Okay, now, the benefits of homeland status, I said, have to be parsimoniously granted, and wherever possible, they have to be made available to everyone in the community on equal terms. And there must be, wherever it is applicable, a robust secular alternative offered. This position, by the way, is a position that we took earlier. If you remember my describing public funding in the United States, we said public funds could go to religions, but they had to go to everyone if they could, and they had to give rise to services that had a robust secular alternative. The easy example here, the cheap shot, but it's quite astonishing, is Israel's marriage laws. Israel's marriage laws, roughly speaking, are these. First of all, there is no secular marriage. Secondly, religious marriage is distributed prominently to the Orthodox Jewish rabbinate and then to other non-Jewish groups. So that, for example, secular or progressive or non-Orthodox Jews have no marriage home in Israel. They go to Cyprus. They, at one point, went to the Guatemalan consulate. I'm not sure how that Guatemalan consulate was Guatemalan soil or some crazy thing. And you might think that marriage, all this is kind of trivial, except that for those people to whom these things matter, the symbolic importance of all this is quite dramatic. Now, who knows why the Orthodox rabbinate in Israel was given a kind of mini theocratic control over marriage? You might say that was the only way you could create for this complex group of people, the Jewish people, the comforts of recognition would be to provide a group of them this special power. More likely it was done for, sort of bald political reasons, but it doesn't matter. The critical thing is, if you were going to make mini theocratic control over marriage available, it has to be made available to everyone. It has to be made available to progressive Jews, to secular Jews, and there needs to be a robust secular alternative, which is the most powerful way of ensuring equality here and satisfying the needs of people who want a secular marriage. So the mini theocratic rule of the Orthodox rabbinate, on our account, is okay. But it's only okay if the equivalent is available across the spectrum of belief and non-belief, and that includes a robust secular alternative. Now, that's not what I've just said is not without controversy. I talked a little bit about this at Columbia a week or two ago, and I discovered it definitely is not without controversy, and we can talk about why it might be controversial. But that's an instance of inhibiting the reach of the comforts of recognition as guarded by the principle that they, wherever possible, be shared across the culture. Something else we say, and this will come back, something we endorse among the partiality of Israel in the name of the minima of assuring comforts of recognition and their durability is we think it is appropriate for Israel to have what in some ways is an asymmetrical or partial right of return, for a genealogically identified people. We can talk about that, but it has immediate consequences when we talk about solicitous inclusion. So the second principle, to stay at the general, to take refuge in the general again for a moment, is the comforts of recognition need to be parsimoniously distributed, and most crucially, they need to be shared. The attributes of those, or the artifacts of those comforts of recognition, seem to be shared on fair terms wherever that is possible, and it is often possible. That's true with symbols, it's true with holidays in some ways, it may be true with museum displays and so forth. Okay. The third requirement of a partial state like Israel satisfying equal membership is probably the most demanding of all, and that's the question of solicitous inclusion. And that's a very demanding requirement because the idea is the state has to do whatever is necessary to maintain an environment of equal status or equal stature in the face of its homeland commitments. And those requirements are both material and symbolic, and I'll make gestures towards each. On the material front, in the case of a partiality as prominent and as extreme as Israel being a Jewish state, there may have to be fairly prominent structural commitments in order to make equal membership plausible. And this has become clearer to me, in fact, since Ben heard me, or Chris and I talk about some of this, and even other presentations in writing, the structural sides of solicitous inclusion may be very dramatic. They might include, for example, ethnic representation or the equivalent, some way of insisting that political life is fairly shared. They might very well include, and probably do in the case of Israel on a variety of grounds, I think a commitment to equal membership may include a commitment to something like the two-state solution with regard to the Palestinians. And that's especially true in light of our of our support for the limited right of return to Israel. They include other things. They include they include extremely robust anti-discrimination laws of employment, education, everything. And they include either affirmative action or self-conscious action to assure that the material resources of the state are fairly distributed across the homeland peoples and the minority peoples. Here, it looks to the outside observer as though Israel flunks pretty badly, if I can just drop a short footnote, in terms, for example, of the amount of money, municipal services and concerns that go into the non-Jewish population, which is, there's a fair amount of separation between Jews and non-Jews in Israel geographically, and the communities that house largely Arab non-Jewish population do very poorly in terms of public services, the amount of money that reaches the school, the amount of achievement that comes out of the schools. And that's a powerful moral obligation of a homeland state to take action to try to turn that around in powerful ways. The Constitution needs to have prominent commitments, should Israel have a constitution at some point in the future. And political leaders need to make an emphasis on equal membership a part of their presentation of the values, prospects, and projects of the Israeli state. All that, well, I'm jumping ahead because, so on the material front, we've got structural change, anti-discrimination laws, affirmative action, deep concern with material distributions. On the symbolic side, the stakes are very high. After all, in some ways, there's one very prominent symbol that we're embracing, and that is Israel announcing that it's a Jewish state in the first place. But given that, everything I jumped ahead of myself and started talking about a few minutes ago about a constitution and what it says, leaders and what they say, museums, public displays, public commitments, there needs to be a very powerful effort to create an environment of equal membership. And that can be even in the terms that that the homeland status is defended. And in our paper, we give, I think I would read them rather than try to reconstruct them. There are things that can be said in thought and things that can't be said in thought. So it's quite plausible, to paraphrase our paper, to talk about the justice regarding reasons for a Jewish state, but they can't trespass onto ideas like the Jews being a chosen people. That's anathema to the idea of equal membership. So the line is fine, but tremendously important on a symbolic level. If all three of these things are satisfied, justice regarding purposes, inhibited commitment to the comforts of recognition shared equally where possible, and a robust posture of, and hopefully symbolic, successful posture of solicitous inclusion, we think a homeland state could be a home for the Jewish people, a Jewish state, if you will, and satisfy equal membership. Now, do I have a couple more minutes, or are we about at the?
Yeah, it's right about 5 minutes.
Okay. So that's the rather startling turn that Chris's and my thoughts have taken. I just want to add one last thing, which is going to be so brief as to be not very useful, but at least offers some terrain that we might range over in our conversation. And that's this. In this paper, we also look much less thoroughly and convincingly, I think, at France and the robust secularism of laïcité. And we try to make sense of it as a kind of secular homeland or nationalist homeland. And I'm not going to say a word about the bottom line for France, except to say that we have a somewhat inchoate thought in the back of our minds. And that is that if you look at the United States, you look at Israel, and you look at France, you may see prototypes of three very different ways of accommodating minority religious beliefs and bringing together equal membership in potentia and justice for individual religious groups. And our insistence is that equal membership applies to all three regimes. To the United States, which we think of as just a gaggle of different groups whose unity really exists in embracing a certain form of constitutional government. To France, where a kind of nationalism which is rampant, where France's ambitions is that there be a French people and that equality be realized across those people, but obvious problems occur with the headscarves and veil cases. And to Israel, which is a homeland state ethnically and religiously defined, we think equal membership applies across those, but that it produces different entailments or demands. And that in the United States, you get this sort of ruthless equal treatment insistence that we maintain. In Israel, you get what I've tried to describe, and in France, in a certain way, something similar, but I'm just going to gesture vaguely at that. But we do think that these regime types may be importantly distinguished from each other, and that the entailments of equal membership may apply or may be different in each case. So that's it. That's the perhaps quixotic, I hope not, attempt to pursue religious equality in a partial world, with Israel being the nettle that we've grasped as an indication of how that might be possible. Thanks for being so patient. I'm happy to answer questions.
Thanks so much, Larry. And we're going to do our normal process, which is I'll distribute the microphone for people that have questions, and I know that there'll be many. So. Yeah.
Thanks, Larry, very much for this very, very interesting talk. So first, a couple of kind of brief factual comments, and then a suggestion / question. So first, the marriage law in Israel, yes, indeed, it's crazy. And when you study family law in Israel, you spend much of the time with bizarre cases dealing with a Hindu husband and a Jewish groom, a wife that are getting together, getting divorced, and just spending time on which court has jurisdiction over them. And but to some extent, so historically, it's actually a sort of accident from before the founding of Israel. It's actually not even from the British; it comes from Turkish times. So the fact that now it's sort of a monopoly of religion. By the way, not just the Jewish religion, also Muslim, is sort of something that was what was in the established in the Ottoman Empire and sort of stayed on since then, simply because I suppose no one wanted to touch it. So it was too complicated, too thorny, too explosive to touch. The marriage thing, it was Paraguay and its proxy marriage.
Thank you.
And it's proxy marriage, which, the idea is that you basically send documents, and you then, Paraguay, I guess, used this as a way of increasing revenue. You sent documents to Paraguay, you got them back, and you were married. So that was that. I understand that it's no longer possible.
That's my understanding, too.
Investment in non-Jewish municipalities, it's true what you're saying, but I think it also has to be said, and I actually read something about this just the other day, that the collection of local taxes in Arab municipalities is a very well-known problem, and percentages are very, very low. And so part of the problem is that there's simply less money to go around in Arab municipalities. Now I come to my so I think perhaps Judaism is a religion, and so obviously treating this as part of a project in law and religion helps, but it's sort of a weird religion in some respect, that it's sort of an ethnic group of some sort, which is why many people who don't consider themselves religious at all and don't keep kosher or whatever, still would see themselves as Jewish in some way. And so that suggests to me that perhaps the model on which to think about Israel would be something more of still fairly common idea of an ethnic-based state. So France is perhaps a useful idea. Ireland, perhaps, I don't know. But so and there you do see that. So the question perhaps is in some respects more general. Can we maintain the idea of an of a state that in some respects thinks of itself to be connected to a particular ethnic group? Now, if you allow that, and some people will say that idea is simply not cannot be justified. But if you think that you can have something like that, then perhaps it's an easier route to justifying, at least in principle, the Jewish state, and thinking as long as, at least as far as the state is concerned, Judaism is treated as not as a religion, but rather as an ethnic, some sort of ethnic/national group.
Well, I think I agree with everything you said, Dan, except the notion that it might be easier, or indeed that it might be very different, because I think our paper is actually faithful to this in certain ways. I stand corrected on the pre-Israel founding origins of the marriage laws, and I have been instructed in this on another occasion. Nothing required that they be held constant or extended to the Orthodox rabbinate in this particular way. And nothing I've said, I think, depends on the fact that it was invented more recently. I'm glad to be reminded about Paraguay. I suddenly conjured up this vision of these two piles of paper in front of someone presiding over marriage in Paraguay. I now pronounce you, man and wife. And on the Arab communities, I don't mean to get down in the trenches on the facts, except to say there's at least one Israeli commentator who believes there is no occasion of public discourse in the Knesset in which the condition of the Arab schools has ever been raised or talked about. I mean, there are some extreme claims of neglect, but that it's wrapped up possibly in these other problems and reciprocal, I don't doubt. On the ethnic thing, we are pretty careful in the paper to describe the ethnic nature and complicated nature of the Jews, to suggest that might make things easier. It makes things easier for us mainly because it connects directly to the historic persecution of the Jewish people and the need for a homeland, that the Jews are the Jews in the eyes of other people. To us, remember, it matters less than most people as to whether this is partially or fully religious. For us, what matters is the vulnerability of all this to discrimination, and the vulnerability of a homeland state to Israel to discrimination across the fault line of the Jewish people versus the non-Jewish people is exactly the kind of unease we feel about religion. So we think our analysis transfers pretty easily, given the fact that, bear in mind, we don't justify the special constitutional solicitude for religious discrimination in the United States by something special about the connection between individuals and religious belief, simply because we deny that there is that specialness except in terms of discriminatory nature. We know religion brings out some of the best things in human beings, some of the worst things, but we think Chagall in the South Pacific painting, a poet, a person deeply committed to their ailing. Lots of human passions and commitments are deep and soulful, and we don't think there's a justification that marks the religious from the non-religious. So for us, it's vulnerability to discrimination. In Israel proper, of course, it's a mixed picture because the right to return is genealogical, exquisitely so. The East African in-migration is not one that a lot of Israelis would have welcomed but for their genealogical commitment, and they've sort of stood by and honored that commitment impressively. But on the other hand, the screwy laws of marriage are exquisitely religious. It's the Orthodox rabbinate, not the ethnic people. Well, the only problem is, as an ethnic person, you might be disqualified from finding the right home for your religion. So I don't disagree with the fact that it is interesting and important that the Jews are an ethnic group, but I don't think it changes our analysis, and indeed our analysis tries to embrace that, and I especially don't think it makes it easier because of what I've said. Maybe certain forms of religious partiality would make it harder, I'm not sure, but I'd need to think about that. So thanks for all that. Sorry to go on at such length.
Oh, wonderful. Francois, and I'm ready, and I have a couple of other hands up, and please let me know if you have a question.
Okay, great talk, Larry. I really enjoyed this.
Thank you.
In terms of your proviso that in a state like Israel, whenever possible, opportunities, support, institution ought to be shared across the culture. There ought to be a secular alternative to the religious alternative. What are the contours of that possible when you say whenever possible this should happen? Because presumably that's going to be colored by the commitment to a Jewish state, which its comprehensive conception of the good. And therefore, how far does it go? And so far as the secular alternative, then people buy into this, and suddenly it starts challenging some tenets that are seen as to be foundational. Is that the border? Is that where, in a sense, repression, to use any word, might come in? And second question to this, whose understanding of what it is to be a Jewish state ought to color this understanding of the possible?
Yeah, these are hard questions, and even in the longer, I wish I could say, read the longer paper, we deal with all this. Even in the longer paper, we run into some problems, and I'll describe some sites of this difficulty. As to whose judgment colors this, bear in mind the perspective that we adopt in this paper, which is holding a conceptual Israel up against a requirement of justice as we see it. What comes to mind in some sense is Tom Nagel's famous A View from Nowhere. I mean, the moral commitment is it's a requirement of justice. Now, justice may be in the eye of the beholder, but we make arguments about justice. And our version of justice is not relativistic in any normal sense. And so, we're appealing to the demands of equal membership, and they inhibit what might be very powerful demands of the Orthodox rabbinate to make the world comfortable for them, for example. We've always encountered that. I'm sure all of you who have looked at religious liberty have encountered this. When Stephen Smith wrote the book Foreordained Failure, for example, of course religious freedom or liberty is doomed to failure if you let a religious group define what it needs to be satisfied or comfortable, right? Because it can say, what we need is for every person in this community to be converted to our faith, or we will all be condemned to hell. So we either have to convert these people at whatever cost or expel them. And that may be true, that's what the comforts of recognition would demand, but equal membership can't grant those. So in effect, we say equal membership marks the limit of what can be asked. And that tends to say the vantage is from someone who is seriously committed in a robust way to equal membership. They can be committed to that as a second order, share this planet or share this nation, but it's whoever can accept that commitment. On the question of how this plays out in the domain of what can be shared. I think that is a very serious and tender question, and I'll tell you where it tends to come to a head. It tends to come to a head in terms of public symbols. You know, that because, you know, can a Jewish state insist that the Star of David and the Star of David alone be on its flag? And the notion would be, well, if we share it, you know, we've lost the identification of being a Jewish state, and it's these symbolic things. Our thinking, you might think we've evolved on the side of being more and more sympathetic to partiality. Actually, because we set ourselves the task of trying to explain Israel, we started pretty generous, and as we've thought and talked and answered questions, and sometimes evoked the enthusiasm of people we were uneasy having invoked the enthusiasm of, we've contracted all that, you know, and so we think that, you know, setting aside the one symbol, the flag, for a moment as a site of contention that we go back and forth on, we think symbols either don't exist or they need to be shared. So you want to have a Star of David, super, but then have 6 other symbols. I've often wondered if that meant that the agnostics could ask for a question mark, but I think, you know, by and large, on this tender site of sharing, we think things need to be shared. Now, there'll still be some things, but I think in the end they come out pretty modest. For example, if you're going to have a day of rest in the week, can it be a religiously appropriate day for the Jews? You can't have very easily 6 days of rest. Maybe you can, because you can't share that without sort of undoing the social virtues of a day of rest. Thinking about this for the first time, I got somewhat sympathetic with that aspect of religious law in America, where a uniform day of rest on Sunday is okay, but you can't penalize someone for being unavailable on Saturday. And that's, so there can be shared may really come down to not the can be shared without diluting the meaning, which is in a way what we were talking about, but can be shared mechanically or physically. And we have a pretty narrow view of that. Right? That's more a confession of unease than an answer, but it's the best I can do.
Yeah, I think that my question is very closely related. Maybe just another angle to look at what you were just talking about. But what's been on my mind through your talk is that I wonder whether the difference between Israel and the United States, as you have depicted both of those, is just the fact that Israel is transparent about its commitment, and the states aren't, and places like Canada aren't either. So I guess what this leads me to ask is whether you can say just a little bit more about the equation you seem to make between a secular outlook or the ruthless demands of equality and the kind of way of life that is encompassed or that equality is fitting in, and the implied relationship between that outlook and a kind of neutral ground that to me is really not neutral and is in a way kind of just maybe even more pernicious because it's not transparent because it makes the claim to neutrality. And I'll just tell you where I come from with this question, which has resonances with your definition of the homeland, is that I work with indigenous legal traditions, and so I see the particular homeland that Canada and the US are as being the homeland also of people who are not the majority anymore and who are not recognized as much as they should be, Native Americans and Indigenous peoples in Canada. And I see the state with its pretension to neutrality and the the theory of equality that you propose being a part of that as still very much a colonial state, right? That still makes the determinations, as you put it, of what is religious and what isn't, with big implications for the ability of Native people to govern themselves. So I just wonder if you might say a bit more about the neutrality that's kind of underlying your whole commitments here.
Well, this is a huge topic, and I don't mean to say, by the way, that the United States is just hunky-dory in this or other respects. And I take your question to really be about the United States, and I don't think, and I guess I need to make several passes at this. First, the United States, I want to take a broad step back and confess a certain degree of unfinished business in our thinking in our paper, which I was actually mentioning to Ben earlier today, and that is the question of what we say, of how what we say about Israel, or indeed what we say about the United States, connects to, in effect, the distinct treatment of indigenous people in various national settings, and the idea of a homeland for that people. That's a very rich and important question. And I don't think we have gotten very far in thinking about that, in part because we don't say that creating of Israel a homeland for the Jewish people was a moral obligation, which we might be able to say. Instead, we say it was justified by a strong moral commitment or moral value. It was justice regarding. So we haven't sort of asked what is in some ways the flip question of all this, which is what are the moral obligations of a nation state with regard to its indigenous people? That's number one. Number two, in the United States, I think it's important to distinguish, in part, between two very different issues. One issue is the partiality of the state or public law, and the other is the partiality of the private behavior that the state sort of underwrites by saying we don't touch all this. And the United States is very, I don't think the United States is a homeland for anyone. It sets itself up to be a homeland for lots of peoples, and many minorities flourish, including, for example, in this allegedly anti-religious constitutional regime, there's more religiosity in the United States than anywhere in the modern West. If you ask how many people go to church, how many people do prayers and so forth, it's a very religious nation, and it's a highly diverse nation. Lots of religions flourish. So the theory of pluralism really, in many manifestations, exists in the United States. But its treatment of the Native American people is, in a lot of ways, scandalous and also time-sensitive. So in the name, perhaps legitimate name, of acculturating the Native American people, horrible things were underwritten by the state. And I would never try to justify them. The wrenching of children from their families, the attempt to sort of break reservations apart, and then the later attempt to maintain reservations would be, all that stuff is indefensible and not underwritten by anything that Chris and I try to say about religious liberty. It's just a scandal. Then you have this kind of modern notion where we walk this weird line of maintaining some view of dual sovereignty with regard to Native American peoples. So there's a Native American Bill of Rights, which is different than the Bill of Rights suffered or enjoyed by anyone else. There are separate courts. And then there is this astonishing phenomenon, which still seems to me as though it's out of a kind of a Kurt Vonnegut novel, which is that we have made reparations to Native Americans in the name of dual sovereignty by permitting them to run casinos. I mean, what a bizarre thing, right? A genealogical privilege to profit off of gambling. The Pequots the Pequots, which were down to about 15 people and had been fought by the French, fought by the English, fought by American settlers, done in by many neighboring tribes, are now the richest group of people in the world because they run the world's richest casino in the middle of Connecticut. I don't know what to make of all this. I'm sure that we can do better. I'm sure that a great deal of injustice has been done with regard to the Native Americans. I'm sure there's a lot of hard and interesting thinking to be done about indigenous peoples. I don't actually think, and then this will be the position, I don't think what we say about the United States and religious liberty, or what we say about Israel, actually offers a pretense of justice to what is in this regard injustice. The injustices of the United States with regard to Native Americans, I don't think is hidden behind, justified by, or provoked by our views of religious liberty. It's just an independent and deeply embarrassing piece of our national history. So, and I don't think that the form of equality that we insist on is a pretense. It just isn't universal in the way that one would hope it was. I don't know if that, I don't mean to be defensive, and neither do I mean to satisfy this, but I think it's in some ways independent of religious liberty in the United States.
I'm going to look around for some other hands, but in the meantime, I'm going to hand the microphone over to Edgar, who's joined us today.
Good afternoon, Dr. Sager. My name is Edgar, and good afternoon to everyone. I had when I listened to the arguments you presented about solicitous inclusion, it's an interesting one because the gentleman earlier mentioned taking the perspective of an ethnic identity to try to constitute a structure in a society where you would afford people to identify and to take away a lot of conflict. But I think currently the political situation in Israel is a testament to the dangers of that in terms of trying to come to some consensus with different interest groups, different parties, and even whether it's just the Sephardic group or the Ashkenazi groups. So there will be conflict with that. I think having a universal human rights approach would be more beneficial. It's just in my opinion, and I want you to really delve into this to see how useful it may be. Because what that does, it safeguards and it guarantees the basic human rights for every citizen and every Jew, and even those who are, like you said, genealogically associated as Jews. However, like the East Africans who were not really initially receptive from the indigenous Jews in Israel, but it's a commitment that they honored, which was remarkable in itself. So those conflicts can be reconciled, and I think with the universal human rights approach, it would be a lot better because issues about, as you said, being separate or a chosen people, which the blessing came through Abraham, and everyone is going through that. We know that, but it's also an anathema because it creates a lot of conflict unnecessarily, I think. So I just think that approach would be very helpful.
So are we all the chosen people on this account? I mean, every person is one of the chosen.
Yeah, if you believe and you subscribe to it.
I like that a lot.
You come through that.
I'm all in favor of that. Well, thank you. Well, it's interesting. The idea of one question that for some reason, I should be able to answer, but haven't quite nailed it. How does what I've said, or what Chris and I have said, connect to universal human rights? And you might say, one way to rephrase our question, which is, what forms of partiality, of national partiality, are consistent with equal membership? You could make it a more robust challenge. What forms of partiality are consistent with universal human rights? And it would be, for the same reasons that Chris and I felt we had to raise our gaze and complicate our thinking, because our view of the United States wasn't portable, you would want to be rather careful about asserting that universal human rights meant that no form of national partiality was possible, because almost every nation has forms of partiality, And so you would want, I think it's really important to realize that the demands of constitutional and this is a more general proposition, the demands of constitutional justice, in my mind, in the North American constitutional, in the United States constitutional tradition, on the one hand, and universal claims of human rights on the other hand, they don't depict the perfectly just society. They really announce what particularly flagrant forms of injustice rise to the level that all people have a right against those pronounced injustices. And it's really, if you will, in the space between the unacceptably bad and the ideal that room for partiality may exist in some ways. But I'm not offended at all by the notion that the way to think about this would be in terms of universal human rights. But I don't think that the questions and answers with regard to an ideal Israel would necessarily be very different. For example, let's just take, and this is, I know, somewhat trivial piece of the Israeli picture, but take what I said about, but it's just easier to talk about. You can get your arms around it. Think about what I said about marriage law and an appropriate marriage law regime. And imagine that you maintain the regime that is there, but you make it available to every group that qualifies on some sensible standard, and you have a robust secular alternative. Is there any reason to think that, and this is the hard question, but it's an open question, that the mini theocracy of the Orthodox rabbinate is inconsistent with universal human rights? If it is mini, it's mini theocratic because it only applies to those people who choose or are chosen to be in that group. And I'm not at all convinced that a fair distribution of theocratic, non-theocratic, religious, and secular that was fair would violate universal human rights. It might be a bad recipe for maintaining such things. I'm not here to say this is hunky-dory. And you began, Edgar, by saying, look where things are going in Israel. And you're right, they're not going in a direction that makes you think it's a promising strategy for recognizing human rights. But I don't think these features, well distributed, would be themselves antithetical to human rights. Thank you for your question.
So we have time for a couple further questions, and our first one is Sukhpreet.
I think you've been touching on this a bit, but I'm just wondering, and you mentioned at the end of your talk that hopefully this approach is not quixotic. I suppose I'm going to sound very cynical because to me I feel that it is, especially in the context of modern day Israel, when I know you're theorizing something apart from that. But in the context of any homeland state, and particularly Israel, I do feel that this is a very noble proposition, but one that I don't have much faith in the realization of. So I'm wondering if you could touch on what gives you the faith that I'm perceiving you to at least have somewhat.
I don't necessarily have faith that Israel's going to make it. And I did, it's not implicit in what I said. I don't feel like I'm a judge of that in some ways. I'm not of that culture. I'm not an expert in that culture. What was your name? I'm sorry. Andre, talked about colonialism. I think the Israelis are in this sort of awful position of being a colonial people who can't pack up and go home. And that may be true typically of indigenous minorities. And I don't know whether Israel will make it. I really, really want to insist that Israel for us is the very useful backdrop of asking some hard questions about what could be. Now, it is true that a consequence of what we argue, you could take this if you're persuaded by it, not its possibility, but its theoretical soundness. You could take this as an agenda for change in Israel. And I'd be delighted if it were grasped and taken that way. But it isn't confidence in change that provokes these arguments. It's confidence in the hypothetical state of affairs that we describe. Homelands are complicated, it's perhaps especially ethnically, but for example, and I don't want to take us far into that, but if you imagine a more balanced and less hypocritical French implementation of laïcité, which is this kind of robust public secularism, you could imagine that's a kind of homeland. It's a homeland for the French people, and the French people are now defined as everyone ever within the reach of the French Empire. And that's, of course, part of the issue. Algerians have free access to France and are now a major part of the French population. And if a form of laïcité that didn't draw hypocritical distinctions on the size of religious symbols that just happened to disqualify the headscarf, but not a cross, things like that are, that could be a homeland of sorts, and it could be one form of a just state if it were, and it's reformable. You could imagine a better version of laïcité, and indeed a lot of French do. The Conseil constitutionnel, which is now the more formal constitutional court, at one point struck down one version of the headscarf law. So you can imagine a constitutional tradition that maintained laïcité fairly and moderately, respecting justice. So I don't think all homelands are disqualified. And I don't know what to say about Israel. Someone wiser, more deeply embedded in the culture, and maybe even more optimistic than I about the world, because I tend to be an optimist, might have an optimistic view of Israel. I'm pretty agnostic about it.
All right, just maybe I'll put one brief question before we close. We
Sure.
don't have a lot of time, but I think that the questions might be somewhat related. In the distribution of institutions and in the movement, for example, family law and these kinds of elements, I wondered what your justice-seeking principles said about intragroup dynamics and in-group harms. And that links to the other part, which is really kind of a connection of the first half and the second half of your talk, which is that in your book with Chris, you said we need to augment this equality with a liberty principle, both in a positive and a negative sense, when the state has a warrant to interfere with liberties, and also when individual groups will have a liberty quite apart from an equality. So you had this equality, but I need a liberty principle. And liberty seems not to have traveled with you when you went to the global stage, or has it? And I think the two are kind of linked questions. Do you need a liberty principle alongside the discussion about equality when you go to a partial state? And does that say anything about the in-group harm sorts of issues that are part of a justice-seeking state?
Gee, that's a very good question, Ben, and I don't know, I need to think a bit about it, but I'll say a couple of things. I think more than once I said, this idea of fairly distributing what is now a kind of mini theocratic exclusive of the Orthodox rabbinate is not uncontroversial. And the controversy lies in people who say, you're endorsing the Israeli state being complicitous with the Orthodox rabbinate, and the Orthodox rabbinate is deeply committed to a series of bald injustices, mostly regarding gender discrimination. And the state shouldn't get its hands into gender discrimination, even on a fair basis. That's a really interesting question, this idea of when, and the question, and I'm not going to try to defend our view right now, but the question is, when the state says, look, we'll in effect delegate marital authority to A, B, C, D, E, and F, and does it fine, and we have a robust secular option, is it really complicitous with any of those? Or is it rather like the United States now, where people both have a civil marital status and a religious marital status? They sometimes go on in the same ceremony, but it doesn't matter. So the question is there complicity involved in the Israeli situation? So that's one way to think about the intra-group justice questions. The liberty thing. Where liberty becomes important for Chris and me in the American situation, I'll describe, and then we can talk about whether it's missing from, and although we say a few things, we say some stuff about that with regard to headscarves in France and so forth. But, or whether equality can do all the work that we care about at this moment. Liberty comes into the picture in several different ways. We think robust free speech is a critical aspect of an appropriate regime of religious liberty in the United States. But free speech, of course, is really equality-centered also, right? You know, it's viewpoint discrimination that is the heart of our tradition. So free speech comes in sort of on this, we can call it a liberty, but it really is equality-driven itself in its most robust forms. Then we've always had this problem, which is how should we deal with the ministerial exception? You know, how can you, given what we say it's appropriate for the Catholic Church to only have male priests? Very topical, very timely issue right now. There are lots of things about the priesthood that are going to require some close scrutiny. And our claim was always, it's not because of religion, it's because of the structure of religion, which is that religion takes what in other settings would be intimate decisions, like the decision who to invite to your house, who to seek as a mentor, who to hire as your lawyer or psychologist. We say the state can't tell you that you have to be ethnic or religiously or gender balanced in those choices. That's just private choice. We say the choice of a priest is in the same way a question of intimate association, and that therefore independent notions of freedom explain the ministerial exemption. And when someone says, but what about the broad exemption throughout a church's employment of gender discrimination laws, we say we don't approve those. We approve discrimination on the basis of gender or race or anything else at the level of the priesthood or thereabouts because of this right of intimate association. We don't think that, so that's how it fits in our American thing. Then how this would fit thinking about Israel or France, I need to think harder about it. We certainly don't disavow it, except I want to indicate how small the argument for it is in our overall view of religious liberty in some ways.
Okay, wonderful. Well, we're at 2 o'clock. I know you'll agree that it was an extremely interesting talk, and I hope you'll join me in thanking Larry Sager for his address today. And thank you for coming.
All right, great.